ಸಿಎಂ ವಿರುದ್ಧದ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಬಗ್ಗೆ ವಿಚಾರಣೆ ನಡೀತಾ ಇದೆ. ಹೈಕೋರ್ಟ್ನಲ್ಲಿ ಅರ್ಜಿ ವಿಚಾರಣೆ ನಡೀತಾ ಇದೆ. ಹೈಕೋರ್ಟ್ ಏಕಸದಸ್ಯ ಪೀಠದಲ್ಲಿ ವಾದ ಪ್ರತಿವಾದ ಮುಂದುವರಿತಾ ಇದೆ. ವಾದ ಪ್ರತಿವಾದ ಮುಂದುವರಿತಾ ಇದೆ. ನ್ಯಾಯಮೂರ್ತಿ ನಾಗಪ್ರಸನ್ನ ನೇತೃತ್ವದ ಪೀಠದಲ್ಲಿ ವಿಚಾರಣೆ ಆಗ್ತಾ ಇದೆ. ಇವತ್ತು ಎಲ್ಲರ ವಾದ ಪ್ರತಿವಾದ ಮುಕ್ತಾಯಗೊಳ್ಳುವ ಸಾಧ್ಯತೆ ಇದೆ. ಇವತ್ತೇ ಸಿಎಂ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಭವಿಷ್ಯ ನಿರ್ಧಾರವಾಗುತ್ತಾ? ಹೈಕೋರ್ಟ್ನಲ್ಲಿ ದೂರುದಾರರ ಪರ ವಕೀಲರು ವಾದ ಮಂಡಿಸ್ತಾ ಇದ್ದಾರೆ. ಸ್ನೇಹಮಯಿ ಕೃಷ್ಣ ಪರ ರಾಘವನ್ ವಾದವನ್ನ ಮಂಡಿಸ್ತಾ ಇದ್ದಾರೆ. ನ್ಯಾಯಮೂರ್ತಿ ನಾಗಪ್ರಸನ್ನ ಅವರ ನೇತೃತ್ವದ ಪೀಠದಲ್ಲಿ ವಿಚಾರಣೆ ನಡೀತಾ ಇರೋದು. ಏಕಸದಸ್ಯ ಪೀಠ ಇದು. ಇವತ್ತೇ ಸಿಎಂ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಭವಿಷ್ಯ ನಿರ್ಧಾರವಾಗುತ್ತಾ ಅಥವಾ ಏನಾಗುತ್ತೆ ಅನ್ನುವಂಥ ಕುತೂಹಲ ಇದೆ.
Report or put in cold storage.
You will not permit.
But that is an independent and a parallel remedy. That is not necessarily a bar to a sanction under 17A. Therefore, my lord, this submission I made is in answer to the aspect, my lord, of eroding public confidence in public administration. How is it eroded? The very fact that you constitute a commission of inquiry indicates that there is something to be inquired into. Is it something that does not require, is a matter of public importance, is what the Commission of Inquiry Act says.
Then there is something being inquired into.
Yes. Yes.
Why all this exercise?
My lord?
Why all this exercise?
Of course, my lord, there are two parallel remedies. Of course, there are two parallel remedies.
Don't emphasize on what is being inquired into.
No, that is only to answer the question, my lord, as to where is the erosion of public confidence. If there was no fear of erosion of public confidence in public administration, then the question of constituting a commission of inquiry would not arise. It is from that point of view I am making the submission. That the very fact that the government itself considers that there should be an inquiry into this matter and a matter of public importance itself indicates there is something that required to be inquired into. And all that is required under section 17A is that there is something to be inquired into. And the entire allegations, my lord, are with respect to persons holding public office. Maybe, my lord, ultimately after inquiry, there will be a clean sheet. Maybe not be, I don't know. But why scuttle it at this stage? I mean, why not? Whatever is the truth. Maybe, my lord, there is truth in what is being alleged. Maybe there is truth in what is being said for the other side. We don't know at this point of time. Therefore, at this point of time, would your lordships want the cloud on the purity of public administration to remain? Is a question, my lord, I ask myself and pose it for your lordship's kind consideration. And I would say, my lord, that in matters of this kind, the courts must lean in favor of getting matters inquired. Not
ನೀವು ಅಷ್ಟೊಂದು ಪಾಸ್ ಕೊಟ್ಬಿಟ್ರೆ ಮಧ್ಯದಲ್ಲಿ ಕಷ್ಟ ಆಗುತ್ತೆ.
ಅದು
Courts which side lighter way. Yes.
ಅದೇನಾಗುತ್ತೆ ಅಂದ್ರೆ
Lighter ways.
I know.
Mind. Yes.
No. I fully
Yes,
understand.
yes.
I fully understand, my lord. We have seen your lordships for quite and we have gauged, my lord, to the best of our ability
Yes.
as to what the court means when the court is asking a question. We know that. The one thing that we are never able to gauge, my lord, and rightly so, is what is the final decision.
Oh, if you gauge that, then what is
Exactly, we can't do that. Adu ಸ್ವಲ್ಪ ಕಷ್ಟ.
Yes.
Adu best is not to do it, my lord.
Yeah.
So now, my lord, coming back to the point, my respectful submission to your lordship is please lean in favor of getting matters inquired into. That consideration when your lordships are looking at 19 would be different. And we are not concerned with that today. In a different. Now, my lord, having told your lordship that, my lord, I prepared a list of dates and factual aspects, and I want to take your lordship through a few factual aspects, which is relevant.
ರಂಗನಾಥ್ ರೆಡ್ಡಿ ನಿಮ್ದು ಲಿಸ್ಟ್ ಆಫ್ ಡೇಟ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ. ಪೂರ್ತಿ ಇಲ್ಲ. ಎಸ್.
Please note, my lord, just a few things. That between 1996 and 1999, I mean, this is not there in this. I would trouble your lordship to kindly just note these periods.
1990?
6 to 1999. The petitioner was the deputy chief minister.
ಇದ್ರಲ್ಲಿ ಇದೆಯಾ ಅದು? ಇಲ್ಲ.
ಅದೊಂದು ಮಿಟ್ಟೋಗಿದೆ.
ಮೋಸ್ಟ್ ಇಂಪಾರ್ಟೆಂಟ್ ಬಿಟ್ಟು.
ಅದಕ್ಕೋಸ್ಕರ ಅಧ್ಯಕ್ಷ ಐ ಆಮ್ ಸಾರಿ ಐ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್.
ಆಯ್ತು.
ಅದಕ್ಕೋಸ್ಕರ ಶುರು ಮಾಡಿದೆ ಅದನ್ನ ಬಿಟ್ಟೋಗಿತ್ತು, ಅದಕ್ಕೆ ಶುರು ಮಾಡಿದೆ. 1996 to 1999.
ಹಾ.
The petitioner was deputy chief minister.
ಡೆಪ್ಟಿ ಚೀಫ್ ಮಿನಿಸ್ಟರ್. ಹಾ.
2004 to 2000, I'm giving the dates which relevant. 2004 to 2005, he was again a deputy chief minister.
1 year.
Yes.
ಆಮೇಲೆ
The first stint as chief minister was, my lord, between 2013 to 2018.
18.
And thereafter, my lord, the second stint is from May 2023.
One moment.
We are concerned with the property, my lord, bearing number survey number 464,
ಕೆಸರೆ
measuring
ಗ್ರಾಮ.
3 acres and 16 gundas.
ಕೆಸರೆ ಗ್ರಾಮ ಕಸ್ಬಾ.
Exactly, my lord, exactly.
Yes.
My lord, this property was originally owned by one Ninga.
Granted.
Yes, my lord, it was granted and he was the owner. And he, my lord, had 3 sons, Mallaya, Mailaraya, and Devaraju. My lord, Mallaya and Devaraj relinquished their right in favor of Mailaraya. That your lordship gets it, my lord, at serial number 2 in the list of dates. Relinquishment deed by Mallaya and Devaraju over survey number 464 in favor of Mailaraya. Therefore, my lord, Devaraju had no right. It was property was owned by Mailaraya. It is noted that Devaraju name is shown in the revenue entries after Ninga and the name of Mailaraya is not depicted in the revenue entries. Then, my lord, I am going to skip to a few things. Then your lordship may come to serial number 4. In 1991, Karnataka Urban Development Authority's incentive scheme for voluntary surrender of land rules 1991 came into force, while GO dated 29th of January 1994, retrospectively from the year 1991. According to the rules, a person is entitled to 4,800 square feet when the land is acquired between 3 acres to 4 acres. That is, my lord, they were entitled to, my lord, 2 sites. If the
Between 3
land
acres.
is in excess of 3 acres.
3 acres.
My lordship may look at the rules, my lord. Your lordship may look at the statement.
All right. ನೀವು
Yes.
Yes.
Then, my lord, please look at serial number 6. No, I'm going to skip a few dates, my lord. May not be.
No
It is given only for the
No, you
purpose of
can-
convenience. I'm
Narrate all the dates, no problem. But rules will go later.
very well, very well.
Yes.
Now, my lord, please look at serial number 6. Government of Karnataka acquisition of land for development of Devanuru third phase by MUDA, 3 acres 16 guntas of survey number 464 was mentioned in notification. Notification reflected late Sri Ninga's name. My lord, we have the notification is available for your lordship's consideration. Now, my lord, kindly see interestingly what happens is serial number 8. Devaraju sought for denotification of land.
Devaraju was not the owner.
No,
Mailaraya was the owner.
exactly.
Mailaraya
was the owner because of the 1968 relinquishment
All
deed.
right. Yes.
Devaraju sought for denotification of the land. Endorsement of MUDA recommending denotification of land, that is on 30th of August 1997. And now, my lord, final notification issued on 20th of August 1997 where this property is acquired. It is at serial number 40.
It was not yet denotified.
No, it was in fact this is the final notification.
No. But what is this denotification?
The recommendation. He made an application, there is a recommendation.
Recommendation on 38/1997.
Yes, correct.
All right. But just before that, a final notification is issued.
Yes,
All right.
exactly. And the notification and that relevant property, my lord, is at serial number 40 of the notification. There are number of properties. Then, my lord, 30th of March 1998, an award is passed. And the amount, my lord, has already been deposited in the revenue treasury. It has been deposited. So with that, my lord, acquisition is over now. There's nothing more to be done. Then comes the notification, my lord, at serial number 11. 18/5/1998, where there is a denotification of the survey number 464. This is where, my lord, the problem starts.
This was the only land denotified or anything else?
My lord, I'll check, my lord. I'll check until I answer your lordship's question. My lord, kindly, I tell you, lordship, my lord.
No problem. Later you can tell.
My lord, answer to your lordship question is only this land.
Only this land?
Yes. It is at page 109.
Nobody had applied for denotification?
No, my lord, I don't know whether anybody had applied, but the fact of the matter is that the denotification of 18/5/1998 is pertaining only to this land.
All right.
And we are given the reference number, my lord, as a statement of objections.
Huh.
Then, my lord, interestingly, on 25/8/2004, Devaraj, my lord, sold this property to B.M. Mallikarjun, my lord, who is the brother-in-law of the petitioner. And thereafter, there is a site inspection report. My lord, your lordship gets a site inspection report. Is it in your new list of dates, 5/3/25?
Is there?
My lord, there is
Yes.
one site inspection report
He has
of
taken this.
5th of March 2005. Your lordships have seen that, my lord.
2 inspections are done. DC says he himself has inspected
Yes,
it and
correct.
conversion is granted.
Correct. In that, I'm going to point out some very telling facts,
Huh.
which I'll come to. Shall I do it right now, my lord?
Yes, sir.
Please be kind enough to turn to page 125.
Of the objections,
Yes, my lord. My lord, page 125 is a communication from the Tahsildar to the Deputy Commissioner, dated 5/3/2005. Please be kind enough to turn to page 126. And he says, my lord, he has done an inspection on 4/3, and the last paragraph at page 126. ಸ್ಥಳ ತನಿಖೆಯಂತೆ ಕಂಡಂತೆ ಹಾಗೂ ಅರ್ಜಿದಾರರ ಕೋರಿಕೆಯಂತೆ ಕಸಬಾ ಹೋಬಳಿ ಕೆಸರು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 466ರಲ್ಲಿ ಒಟ್ಟು 3 ಎಕರೆ 32 ಎಕರೆ ಜಮೀನಿದ್ದು, ಈ ಪೈಕಿ 16 ಗುಂಟೆ ಜಮೀನಿದ್ದು, ಈ ಖರಾಬಿನಲ್ಲಿ 5 ಗುಂಟೆ ಆ ಖರಾಬಿದ್ದಕ್ಕೆ ನಿಯಮಾನುಸಾರ ಪರಿವರ್ತನಾ ಶುಲ್ಕ ವಿಧಿಸಿ ಉಳಿಕೆ 3 ಎಕರೆ 16 ಗುಂಟೆ ಜಮೀನನ್ನು ವಸತಿ ಉದ್ದೇಶಕ್ಕಾಗಿ ಭೂ ಪರಿವರ್ತನೆ ಮಂಜೂರು ಮಾಡಲು ವಿಶಿಷ್ಟ ಕಡತವನ್ನು ತಮ್ಮ ಅವಗಾಹನೆಗೆ ಸಲ್ಲಿಸಿದೆ. Now please look at the next one at page 127. This, my lord, is spot inspection. ಮೈಸೂರು ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ಕೋರಿ ಶ್ರೀ B.M. ಮಲ್ಲಿಕಾರ್ಜುನ ಸ್ವಾಮಿ ಬಿನ್ ಮರಿಲಿಂಗಯ್ಯ ಮೈಸೂರು ಇವರು ಸಲ್ಲಿಸಿರುವ ಅರ್ಜಿಯ ಬಗ್ಗೆ ತಾರೀಕು 17/6/2005 ಸ್ಥಳ ತನಿಖೆ ನಡೆಸಿರುತ್ತೇನೆ. ತಾಲೂಕು ತಹಸೀಲ್ದಾರ್ ಹಾಗೂ ಇತರೆ ಸಿಬ್ಬಂದಿ ಹಾಜರಿದ್ದರು. ಮೈಸೂರು ತಾಲೂಕು ತಹಸೀಲ್ದಾರ್ ರವರ ಪತ್ರದ ಸೋ ಅಂಡ್ ಸೋ ಪ್ರಕಾರ ಪ್ರಸ್ತಾವಿತ ಜಮೀನು ಅರ್ಜಿದಾರಿಗೆ ಕ್ರಯದ ಮೂಲಕ ಬಂದಿದ್ದು ಖಾತೆಯಾಗಿ ಸ್ವಾಧೀನಾನುಭವದಲ್ಲಿರುತ್ತಾರೆ. This is when acquisition is complete. The question of their being in possession would never arise. This is such a blatant.
No, but it was denotified.
Subsequently.
Huh?
Subsequently. The denotification was in
1998.
1998.
This
Yes.
spot inspection is 2005.
Correct. But it's already acquired. Where is the question of their putting in possession?
No, that is why I asked. Recommendation was made for denotification.
Correct.
Where is the order of denotification?
Nothing, excepting, my lord, what happened on 20th, when, my lord, there was on 18/5/1998.
No, that is an order.
Notification. Yeah, that's a notification.
Then it was denotified.
Yes, it was only on 18/5/1998.
It's all right.
Yes. Yes, my lord. Huh? Yeah, if your lordship says, is there an order of notification? We don't have it. But
Notification.
notification is 18/5/1998. It is at page 109, which when your lordship asked me, is this the only property which has been denotified? My answer to your lordship's question was, yes, that's the only property which has been denotified. Now, the first question that arises, my lord, is where is the question of this denotification? How can this denotification at all be done? Is it not glaring act of doing something which is not provided by the statute? When the property is vested, where is the question of a denotification? Now, in that context, my lord, if possession has been, if they say possession is with the Devaraju. I ask myself, how did possession go to him? Nothing that is available on record for your lordships to come to a conclusion this way or that. That is the reason why, my lord, it is only in areas where it is a gray area that inquiry is required. My lord, in fact, my lord, the very fact that so much of submissions had to be made to your lordships in order to point out whether the needle of suspicion is to be pointed this way, that way, or none at all, itself indicate that something has required to be looked into. It is only that much that is required to be done today. If it was open, black or white, no inquiry is required. It is only in gray areas that inquiry is required. This is a case falling within gray area. Therefore, my lord, all that is required to be done is just inquire into it. I fail to understand, with due respects, why this case has been elevated to the level of taking your lordship's time over and over again for the simple purpose of simply an inquiry. In a situation of this kind, my lord, let us assume, my lord, the PCA Act was not there and a simple complaint had been filed, where there was no this filtration process, my lord. Let us assume it was not there. And I ask myself, if a complaint had been filed with the police authorities,
ಅದಕ್ಕೆ ಫಿಲ್ಟರ್ ಬಂದಿರೋದು.
ಇಲ್ಲ ಬಂದೆ. And it had come to your lordships under 482. I ask myself the question, would your lordship interfere? I would say no. Your lordship would say, look, in the complaint there are some allegations. Let it be inquired into. I ask myself, why is it that same test should not be done for the purpose of 17 years? 19 is a totally different kettle of fish. It's totally different. 17 years, is this a case where your lordships will interfere? I ask myself under 482 if a private complaint had been filed in the absence of PCA. Obviously, you will say, look, allegations are there. There are gray areas which requires to be examined. Let it be examined. What's going to happen to you? Nothing. I think, my lord, that is the way. I'm not oversimplifying it.
Just simplifying.
I'm not even simplifying it. I'm only saying, my lord, that's a legal position. And I think, my lord, we have complicated the issue more than what the issue warrants. It requires to be seen in this way. And if that is done, several objectives would be satisfied. One of them is this a complaint which does not warrant any investigation? If it is in the white area, your lordship will say yes. It doesn't warrant any investigation. That's the object of a filtration process. But this case, my lord, is in the gray. I mean, it's all right to say one way or the other, but we are at the stage of inquiry. Now, my lord, please look at the other dates. Your lordship will kindly look at.
No, you said there is a needle of suspicion.
Yes.
Is it a needle in a haystack or what?
I would not say it's in a haystack, because, my lord, needle in a haystack is possibly something so trivial. We use that expression, my lord, normally to convey a very trivial, a very small thing, something so insignificant.
It's not that.
This is not that. Because it concerns purity of public administration. I can understand, my lord, normally this expression pin in a haystack is only to convey something very trivial.
That's why I said, what kind of needle?
No, we don't know. It requires to be examined. The very fact that there is an allegation that has been made of this magnitude, and prima facie here is Devraj, who was not the owner of the property. He makes the application. At his instance, all this is being done. And he conveys the property in favor of the petitioner's brother-in-law, who gives it to his sister. And in a situation where sites have already been formed, now please look at that, my lord. Please look at now that area. Your lordship may kindly now go to seal number 15. 13, no?
12. Seal number?
My lord, kindly see, my lord, seal number 12. My lord, in 2003, despite survey number 464 is denotified, MUDA forms layout, parks and roads. Sites are allotted by MUDA to various persons. Now, my lord, then comes Devaraju, who says, I am the owner of the property. You have sold my land. He sells the property in favor of the petitioner's brother-in-law. And then, my lord, there is an order of conversion, and then, my lord, there is a gift in favor of his sister. It is on the basis of these documents that the sister now says, please give me compensation / alternate sites. Now, please look at that. Please look at the item number 16. 23/6/2014. Representations made by Parvati for compensatory sites. This is the representation she gives. Now, if an ordinary citizen had made an application like this, I asked myself,
No ordinary person made? No, along with this, there are other applications.
we have
No
nothing
other
on record.
application.
Nothing on record. Nothing on record. We don't have anything on record. Nothing on record.
Then
Nothing on record.
why sites are distributed to everybody?
No. That is the sites which were distributed on somebody else's property to various persons. I'm talking about whether the real owner of a property which had been used by a public authority without going through the process of acquisition.
Right.
No such instance. This is the only instance.
Right.
Now, my lord, please look at, if an ordinary person had made an application like this, what would have been the attitude or the approach of the authority? Look, tell me who you are. What is your source of title? Please prove your title before I can even look at your representation.
And a mandamus before this court.
If that's not done, a mandamus by your lordships.
Direction to consider.
Exactly. Exactly, my lord. Your lordships are right. Consider we have hundreds and thousands of cases where representations are made, not considered. Your lordships issues mandamus saying do it within 3 months, 4 months. No, all this is not necessary in this case, my lord. It's not necessary for obvious reasons. The reasons are not far to see. That is what is required to be examined. What would the authority do if there was a representation by an ordinary citizen with respect to this, assuming that they're taking action, not sitting over it? They would say, look, there is a communication sent by one Parvati. Now, who are you? We don't have your name at all on record. We don't know who you are. Please prove your title. No such exercise. Nothing done. Straight away. Now, please look at, then the rules are amended, make it 50-50. As of 11/2/2015, it is on the basis of this rule of 2015 that 50-50 compensation is given. Lord, I have two as
50-50 compensation.
50% of the extent of land which has been unlawfully
So
occupied.
3.16 acres and about
Yes. About
half of that.
half of that. That's the formula. That's the formula in this new amended rule. Now, my lord, if a property has been acquired and the compensation has all been deposited, the question of even granting one side does not arise. Property has become the property vested in the government. Where is the question of denotification? Now let us keep that aside for a moment. With respect to which rule will you take a decision on the representation that has been made, my lord, on 23/6/2014? It obviously must be with respect to the rule that existed at the time when the allotments were made.
60-40.
Exactly. My lord, your lordship may kindly see when the allotments were made to various persons, my lord.
2004.
2004. I asked myself, how do you apply 2015 and give 50-50? If the encroachment or the illegal occupation was at that point of time, which is the rule which you will apply for the purpose of determining whether a person is entitled to, and if so, how much? By way of
Are you accepting 60-40 entitlement?
assuming, without considering, first submission is that not entitled to anything. No, of course not, my lord. Even 60-40, even two sides is not there. The question of my accepting, my lord, not accepting is not the real issue.
No. By submissions, I'm asking.
No, my lord, I don't. Of course not. I am saying that Nothing was to be done. But in this case, look at this way in which it has been done. How do you give this 50 on the basis of 50-50, which was a 2015 rule, in respect of what is a wrong utilization of the property in 1998? I asked myself, how can it be done that way, my lord? Which is the provision under which they can give this 50-50 rule and give these 14 sites? There is none. It's a submission I would make for your lordship consideration. Because your lordship will kindly see, my lord, that all these sites were allotted. When?
19 allottees in the year 2004.
19 allottees in the year 1900?
2004.
2004, my lord. Yes, your lordship gets it.
2004 ಅಲ್ಲ?
2004. 2003, my lord. 2003.
3 or 4 ಅದು.
3 or 4? Oh.
That's why I said he has threadbare covered everything.
Now we have produced one document. Give me page 111.
2009, my lord.
Give me 111.
On continuous process.
My lord, we have produced.
No,
a
it started at 3, sir, then ended at 9.
Continuous process.
Very in a all I can. All right. Now, how does 2015 amendment apply? How did you apply this 50-50 rule? Well, everything can be overlooked for obvious reasons. You did not find out as to what is the title of Parvati. You did not go into the question as to whether there can be a denotification when the property is already vested. You did not go into the question of how many sites to be given, whether you will apply the 50-50 rule, 60-40 rule, 2 sites, nothing. How many times do you overlook? And my lord, your lordships have said it a number of times that where repeated mistakes are made, it leads to a conclusion of malafide. My lord, one order which is wrong, my lord, we don't allege malafide, and even if you allege, your lordships will not accept. But even with respect to a court, your lordships have taken the view that if repeated orders are made in the same case which is wrong, then there is a ground for malafide. Now, how many times are the mistakes being made? Now, your lordship may kindly look at the next aspect as to what happens, my lord. Please look at serial number 19.
Serial number 18, sir.
My lord, kindly see, now serial number 18 is very important. My lord, in December of 2017, resolutions are passed when the petitioner was the chief minister. What was told to your lordship was, well, it was in 2023. Where is the question? I was not there. That's not the date with reference to which your lordships will reckon this case. The date relevant for the purpose of the present submission would be December of 2017. Your lordship may let's look at that resolution for a minute at page 151 of the writ petition.
Of the writ petition?
Yes, my lord. Yes. My lord, in this, please be kind enough to turn to page 152, serial number 30.